Good afternoon, everyone. It's great to have you all here. I had thought in July that July was my last function as president of Foyle, but I've been dragged back kicking and screaming. I was thinking it was a bit like the Hotel California. You can check out, but you cannot leave. So I feel a bit like that. This will definitely be my last role and event as chairman of Foyle, president of Foyle, and passing over to Noel, who will take over later on and introduce himself to you at the end. As befits this time of year, we felt we'd make a presentation to you all in relation to what has been going on in the year, and various developments, various changes, various cases that have been out there, various amendments in the legislation, all of which are relevant, particularly from a defence perspective in terms of our responding to claims and dealing with claims. It has been an extraordinary year. The pipeline of Court of Appeal judgments that have been coming out and continues to flow is extraordinary. The precedents that are being set, judgments that have, I suppose, swung the pendulum of liability away from a fixed position pro-plaintiff to a more balanced, not necessarily defence-friendly, but certainly a more balanced view of the law and application of the law. I think some of the things that will be talked about by Dean and by Andrew Walker are going to talk about the responsibilities that we have as defence solicitors. We've seen judgments in relation, very recent judgments in relation to how expert witnesses should be employed and engaged, the importance of the independence of function of an expert witness, and very clear guidance given by the Court of Appeal and by Mr. Justice Collins in particular in relation to the responsibility that solicitors have towards the engagement of independent witnesses in terms of the substance of the evidence that they will give and the substance of their reports, even going so far as to hold that their duties that we have as officers of the court is such that if it's felt by the court there's an abuse, there could be a penalty for costs made against the solicitors, which is very scary, but again a measure of the importance and significance of the integrity of the function of expert witnesses. We've seen judgments also in relation to our responsibilities when it comes to affidavits of verification and making sure that we don't just lob something in and send off an affidavit, that we really have to discharge our professional responsibilities of explanation, of ensuring that what we file and what we present meets our professional responsibilities and duties, and again, hugely important. There's also been judgments in relation to a judgment just last week from Mr. Justice Noonan in relation to our reliance upon Section 26 when we believe that there has been fraudulent activity, and we plead it and present it, and we do that in a way that the court doesn't approve of, and the odium that will attach to us, to our client, and the potential for aggregated damages to be awarded as it was in the case before Mr. Justice Noonan just last week. Again, demanding of defence solicitors that we behave in a responsible manner, in a professional manner, and that we can't be blinded as regards our client's view and the instructions that we get, that we have duties and responsibilities beyond that to do what is perceived as the right thing. That can be difficult, and I suspect it'll be a challenge for many of us, particularly if we are acting not necessarily for an insurer who can bring a bit of distance and objectivity to a given situation, but where we're acting direct for a defendant whose own money is involved and who has a bit more personal involvement and engagement in it, as is becoming more the case. We certainly see it a lot in Corrigan in terms of self-insured clients with large deductibles each and every in aggregate deductibles in given years. So they're all going to be challenges. They are challenges, and it's very much a feature of the case law and the changes in law that have been coming about. So without any further ado, I'm going to hand you over to Dean, a junior counsel who is well up and coming and establishing himself extremely well, and I'm sure many of you will know him. Those of you who don't will know him. So I'll hand over to you, Dean. Thank you very much. And then after Dean, we'll have Senior Counsel Andrew Walker to again offer a perspective in relation to things. So with me saying that, it gives me the opportunity now to step down and be gone and not be involved anymore at all. You'll hear from Noel later on. So I'd just like to thank everybody who has joined FOIL and who's been part of FOIL. We've been involved for 3 years. COVID fucked everything up and was a disaster in terms of a lot of what I wanted to do and achieve and to move FOIL forward. So there's, I hope that movement, having been stalled for a bit, will be advanced by Noel and the committee, and I wish them all very well with that. So thank you all very much, personally and collectively. And that's to say, that's the end of me and my role. So over to you now. Thank you.
Thanks very much, and thanks, Michael, for the invite. I've been asked to discuss for the next 30 minutes or so developments in the District Court. District Court doesn't make much law, so those developments will have to come from what we've seen and the procedure that follows in the District Court. The main development, as we know, was back in 2014 when the District Court jurisdiction changed from 6,000 up to 15,000. That happened in February of 2014. And at that time, the Circuit Court caseload under 15,000 amounted to some 65%. So we didn't see much of a change in the District Court caseload after the change in monetary jurisdiction. And one of the developments which we had this year, which I think is very relevant in terms of the future developments for the District Court, was the introduction of the Personal Injuries Judicial Guidelines. And these guidelines came into effect on the 24th of April last year. And one of the key issues which we've seen from these is a more nuanced and detailed assessment of some of the more soft tissue type injuries which we've seen. So the previous book of Quantum would have had a soft tissue neck injury of up to 15,000 for substantially recovered and up to 19,400 where recovery was expected. What we now have by way of our judicial guidelines is a more stepped approach to what is the appropriate quantum in terms of soft tissue injuries. So we have, particularly for our neck and back injuries, there is an approach based on time. So we see for a soft tissue injury to the neck, where there is a substantial recovery within a period of 6 months, we have 500 to 3,000 euro. Again, if there is a recovery within a period of 12 months, we have 3,000 to 6,000 euro. And these are all in the minor category of injuries. And that categorization of quantum puts these cases firmly within the District Court. And we even have a situation now where our moderate neck injuries are still within a District Court quantum where you have 12,000 to 23,000 euro. So the effect of this is that our litigants and our plaintiffs are very much at risk if they decide to issue in the Circuit Court. And what we will see, I feel, over the months and years ahead is a much greater personal injury caseload in the District Court. And the recent court service report, which came out in July of this year, looked at some of the figures and cases and proceedings which have been issued in 2021 and in 2020. Now, obviously, COVID has had a bit of effect on the cases being issued and indeed the cases being heard over these 2 years. But what the Court Services annual report outlined was that in 2021 we had 37% of personal injuries awarded made by the Circuit Court below 7,500 euro, and that was 40% in 2020. And between the period of 2021 and 2020, there was quite a marked increase in District Court proceedings being issued. So the District Court civil business accounts for almost 65% of all business in the civil courts. That's from the district up to the Court of Appeal. Previously, that was 57% in 2020. So there is a clear increase in District Court cases from 2020 to 2021, and it's anticipated that that increase will continue into 2022 when we actually see some of the personal injuries judicial guidelines awards and the assessments coming into effect more so in the court. So in terms of the district court itself, there's two issues which I'd like to address. The first one is pleadings, and I know Michael referred to the recent case law which is coming from the Court of Appeal and which has persistently been for the last number of years in terms of the importance of proper pleadings in personal injuries litigation. And we'll have a look at that briefly. And I also want to look at the issue of time when you're issuing proceedings in the district court, because the district court has a hangover from one of our older pieces of legislation in terms of assessing time and when time runs in the district court in respect of proceedings. And if Andrew Walker doesn't run in the door, I might briefly discuss an addition to the district court and indeed the circuit court, which we've seen both in personal injuries and in material damage litigation, which is the inclusion of credit car hire, where you're seeing very large claims for car hire, and this is car hire which is being obtained on credit by plaintiffs, and it's something which is very much an issue in the UK, and it's something we haven't seen in Ireland, but it's increasingly coming across my desk, where you have claims of 6 or 8 grand for material damage, and then you have a 8 or 9 grand claim for car hire, because the person is relying on this credit car hire. So the first issue to look at is the issue of pleadings in the district court. As I mentioned, the rules of the district court were amended back in 2014 and included 40A, which mirrors in effect Order 5A in the Circuit Court and 1A in the High Court, which is in effect our personal injuries requirements in terms of pleading and amongst other things our affidavits of verification. And the rules in the district court are very much no different to the rules in the Circuit Court and the High Court in terms of our pleading. And if I can just go through perhaps Order 40A, Rule 6, which looks at our pleadings, and it confirms that, as Mr. Justice Collins had outlined in the Morgan versus ESB case, that there's an obligation on our personal injuries litigants to set out fully and precisely the basis for their claim, the material facts upon which the claim are based, and the acts of negligence which it is alleged. And the claimant is supposed to set out in precise terms the acts of the respondent which constituted the wrong and the circumstances relating to that wrong. And Judge Collins and indeed Judge Noonan in previous litigation or in previous cases looking at the issue of pleadings in personal injuries cases seem to be quite surprised that we're 15 years after the 2004 Act, Civil Liability and Courts Act, and yet still most of our pleadings in the District and Circuit Court and indeed in the High Court in respect of personal injuries litigation is very much generic pleadings saying if we have an accident at work, it's a failure to have a safe system of work or a failure to properly train the plaintiff. But the case law quite clearly says that that's not enough. And the decision of Morgan versus ESB and Mr. Justice Collins in 2021 highlights, in fact, not only that the pleading of generic or boilerplate terms in our particularisation of negligence isn't enough, but that the court, it appears, won't consider them unless it's properly pleaded in line with the 2004 Act. So in the decision of Morgan versus ESB, we had an accident at work. The plaintiff was walking down a set of stairs carrying a large bundle of post, and he slipped on the stairs, and the pleaded claim was on the basis that the stairs were wet and that it appeared that the wet or leak had come from a skylight which was above the stairs, and that was the claim as pleaded by the plaintiff. The case ran in the High Court before Miss Justice O'Hanlon, and the court ultimately found that whilst it wasn't confirmed whether the stairs were wet, and it certainly wasn't highlighted in evidence that there was a leak from the skylight, the High Court found ultimately that the stairs had caused a hazard and awarded damages accordingly to the plaintiff. It was appealed to the Court of Appeal, and Mr. Justice Noonan and Mr. Justice Collins both gave judgments. And again, similar to the previous decision of Crean versus Harty, which was very critical of defendants in terms of pleading generic pleas in their personal injuries defences, the court in this instant looked at the plaintiffs and the plaintiffs' pleaded claims. And Mr. Justice Collins maintained that this practice of generic pleas has to end in effect. He maintained that the days of making allegations in pleadings without factual or evidential basis have long since passed, and they certainly ought to, having regard to the provisions of Section 14, which, as we know, is the requirement to verify our pleadings. And the court was quite critical of considering the provisions of Section 10 of the Civil Liability in Court Act, which requires us to particularise fully our personal injuries claims, and the obligations under Section 14, which is to verify those facts and those allegations. And the court maintained that personal injuries cases are required to be pleaded in a manner which states clearly and precisely what the act or omission of the defendant is alleged to have caused the injury, and why it is said that such act or omission was wrongful. And this instinct to plead broadly and generally has to be curbed. And in that case, there was a claim that the plaintiff hadn't been properly trained. And Mr. Justice Collins went so far as to say, you have to set out what deficiency was present in the training in order to rely on a general plea that you haven't been properly trained. And the court's view in that instance was it's on the basis of basic fairness that the defendant is supposed to be able to understand what they have done wrong in their training so they can address it. So in tying that back to order to the district court and the district court rules, the same provisions apply in the district court as they apply in the circuit and the high in respect of pleading and specificity in pleading, as do our obligations to verify our claim. And Order 40A Rule 9 provides defendants and plaintiffs the ability to dismiss proceedings or stay proceedings if the case isn't properly pleaded. That says, if we haven't complied with Section 10 as a plaintiff and set out the precise terms of our claim, or if we haven't complied with Section 12 as a defendant and set out the precise terms of our defence. And as we see in the district court, and the fact that we're going to have a greater number of district court cases, district court judges are receptive to these types of arguments. It's very much not something which is dismissed by district court judges. Now, we do have a broad variety of judges up and down the country, but I have seen to date the claims in respect of pleading or a lack thereof being considered strongly by district court judges. The next issue I want to discuss is the calculation of time in the district court. And this is an unusual rule, and it is linked to the 1964 Courts Act. And older solicitors and colleagues here would be aware of this rule having a very significant effect. Many years ago, it was repealed in the Circuit Court about 21 years ago. But in the district court, it still remains. And it came up in a case I was involved in about 12 months ago, where I had looked at the personal injuries summons, and the plaintiff was very tight on the statute in that it looked like they had just got in time. And in the district court, there is a rule which maintains that if you decide to serve your proceedings by way of registered post, that the date of issue will be the date when the proceedings were served by registered post. And in that case, it meant that once the proceedings were issued within time, they'd been served a couple of weeks later and were in fact out of time. And I'm just going to bring you through the relevant rules and the section, because it's something which, in speaking to some of my colleagues, they weren't aware of and speaking to some of my older colleagues, maintained that this was an issue which was prevalent in the circuit court, and it was changed because we had a situation where proceedings were being issued in the central office in time, and that a claim of statute of limitations was being made if they had been served by registered post. So Order 40, Rule 4, Sub-Rule 5 of the District Court rules confirms that, except in a case to which Section 7.6 of the Courts Act 1964 applies, a claims notice which has been issued by a clerk is deemed to have been issued on the date on which it was filed by the clerk for issue. Now that confirms that except in the case to which Section 7.6 of the 1964 Act applies. Now, Order 40A, if we need more confirmation, which concerns personal injuries litigation, confirms that Rule 3, Sub-Rule 3, that except in the case to which Section 7.6 of the Courts Act 1964 applies, personal injury summons which have been issued by a clerk are deemed to have been issued on the date on which the summons was filed. The effect of this is that if you decide to serve by registered post a personal injury summons or a claim notice, you're basically forfeiting your issue date from the central office or the court office, and you are instead relying on the date of service. And Section 7.6 A2 of the Courts Act states this. So it confirms that where service of a document on a person is effected by sending a copy thereof by registered post in an envelope addressed to that person, the document should be deemed to be issued at the time at which the envelope is posted. And when I first looked at this, I was quite concerned because it seemed a little unusual. And there's a decision of Mr. Justice Murphy, there's a decision of Murphy versus McNamara from 2003, which dealt with the order and dealt with the section. And in that case, the plaintiff's proceedings were dismissed. These were personal injuries proceedings. They were under the old 3-year limitation period. It was a road traffic accident which had occurred on the 14th of July 1995. The proceedings had been issued on the 8th of July 1998, so they were within time, they were within the 3-year period. The proceedings were served by registered post on the 14th of July 1998, so 1 day out of time. The defence raised the statute, arguing that the proceedings having been served by registered post fell within the then Order 10, Rule 3 of the Circuit Court rules, which mirrors the District Court rule. The High Court, the Circuit Court dismissed the proceedings and it was appealed to the High Court, and the High Court confirmed in dismissing the appeal that whilst they had great sympathy for the arguments advanced on behalf of the plaintiff, it seemed that when the plaintiff's solicitor chose to serve the civil bill by prepaid registered post, they automatically attracted the provisions of Section 7.6 of the 1964 Act, whereby the civil bill is deemed to have been issued at the time at which the registered envelope was posted. In the case I was involved in, I had, this is not unusual, I didn't draft the proceedings, I just received them a week or so before the trial. I highlighted this issue, and in our situation we had a problem was we'd have to amend the defence in order to plead the statute, which could attract costs and would ultimately be a pointless exercise. So in that particular case, I discussed the matter with my opposite number, and he realised the difficulty he was in, and the proceedings were compromised for a very nominal sum. But the reasoning and the point of this is that this rule still applies in the District Court, and it's not something which is regularly addressed in the District Court. The Section 7.6 and the 1964 Act is still in being. Section 7.6.2a was repealed for the Circuit Court in 2002, and that's it expressly said the repeal was for the Circuit Court only. Now, it may be a case that this will be repealed for the District Court, but at present it's still there, and it's a potential point for both our plaintiffs and defendants when considering cases. So I see Mr. Walker has arrived, and I think I'll pass over to Mr. Walker now. Thanks very much, and thank you for the invite.
Afternoon. Sorry, if you're all happy to start with me without a break, that's fine. Apologies. Sorry, Andrew Walker is my name. If you don't know me, I'm looking at a few faces I do recognise. And I'm replacing Shane English, who has better things to do, he said, than go and meet a bunch of insurance lawyers. Quote, not unquote. And obviously it is a representation of insurance lawyers. Just thinking on my way walking up, the cases you might feel are a bit unnerving for insurance lawyers, but it's in the context of maybe what not to do in cases. I'm going to simply refer to 4 or 5 very recent cases from the insurance point of view, personal injuries cases, which you may or not be aware of. The first 2 cases deal with when you have multiple injuries and what the court should or should not do. The first case deals with multiple injuries in the context of the personal injuries, in the context of the Book of Quantum, and predate the judicial guidelines. And the second case is a decision of Mr. Justice Coffey, which deals with the judicial guidelines. The first case is a case of Meehan and Shaw Cove. It's a decision of Mr. Justice Noonan in the Court of Appeal in September of this year. And if you don't know the facts, just very briefly, this was actually a fairly not tragic, but very traumatic incident. The family attended a wedding in Killarney, and after the wedding, they, I think, went back to their hotel and they got in a lift. The lift went up and then went down, and there were at least 4 or 5 members of the family, 5 in the lift, and they all suffered a number of injuries. Mr. Meehan suffered a number of injuries, including compression fractures to the lumbar spine, a hairline fracture to his thoracic spine, left ankle and left heel injuries. Now, Mr. Meehan had a pretty successful quality control job at the time. He was out of work for a number of months. Part of the claim for his general damages included the fact that his mother-in-law had to come and assist with him. I'm not going to make any Les Dawson jokes about the fact his mother-in-law had to move in. He also suffered a number of post-traumatic injuries. So he quite clearly had suffered serious injuries. And in the High Court, interestingly, the defendants had scheduled a number of obviously orthopaedic and other witnesses and had disclosed these reports, but none of them were actually called in the High Court. And in the High Court, the plaintiff was awarded €125,000 general damages for the past and 175,000 general damages into the future, as well as a loss of opportunity amount of €75,000. It was appealed, the defendant appealed that to the Court of Appeal, and the Court of Appeal said, well, the first thing was in multiple injuries there had to be proportionality to the assessment of general damages, and where the cap in that instance at that time was €500,000. And the Court of Appeal reviewed, and the Morrissey case, which you're probably aware of, and the cervical check, which and the Supreme Court had dealt with, had set the cap at €500,000. So the Court of Appeal, Mr. Justice Noonan, first noted that there shouldn't be an upward creep, was the phrase he used, where there are multiple injuries, i.e. so that in this case the plaintiff had been awarded €300,000, which was creeping towards the most one could get of €500,000, and where you were dealing with modest and moderate injuries. And as Mr. Justice Noonan said, it could lead to a situation where it wasn't just and fair for those attracting the highest level of damages. Mr. Justice Noonan went on to consider the Book of Quantum. He actually did consider the judicial guidelines, even though it wasn't a judicial guideline case. He went on to say that you were to avoid giving separate damages for each injury, as that would lead to possibly overcompensation, and that would offend the doctrine of proportionality. Mr. Justice Noonan, interestingly, he actually then went on to consider English authorities, and I think German authorities as well, and notably it would appear in England and Germany their level for serious or catastrophic injuries is in around €500,000 as well. So from that perspective, the Irish jurisdiction is not out of kilter. Mr. Justice Noonan went on yet to take an holistic approach to the injuries. And what was interesting there was, even though the injuries are outlined at the front, the main injuries Mr. Meehan had by the time the case came on, and the main injuries into the future were both right and left knee injuries, which had manifested themselves sometime afterwards. And it was common case, well, albeit the defendants didn't call a doctor, that he was going to need total revision surgery into the future to both of those knees. And in that case, Mr. Justice Noonan felt the €300,000 which had been awarded to Mr. Meehan was more appropriate in a case of, and just the quote was, a serious and permanent disability, and that disability had to be severe enough to compromise a plaintiff's normal daily activities, include being unable to work, and then again at paragraph 57 quoting, that to attract €300,000 damages, that his lives to be destroyed to a significant extent. In that case, Mr. Meehan, as I say, he'd been a quality controller. He then actually travelled to Korea quite a lot. He gave evidence that was travelling was sore and painful. In fact, he had actually got promoted. He'd actually moved to a new company by the time the case came on. So he wasn't somebody who was unable to work. He was pained in the work he had to do, especially by travelling. And Mr. Justice Noonan and the Court of Appeal, they maintained the €125,000 to date award, but they reduced the future pain and suffering down by €100,000 to €75,000, making a totality of €200,000. They then actually reduced the loss of opportunity claim. I think they reduced that down to from €75,000 to €25,000 as well. Obviously taking into account that Mr. Meehan had been able to get promotion, even though he'd led evidence that he was obviously stalled, as it were, for a period of time in his work. And just very briefly, the other thing to be taken from that case was there was then a discussion at the end. As you may be aware, there's a convention that if you appeal damages only, if the Court of Appeal or the Supreme Court previously, and again in the Reddy and Bates case, which I'll come back to, the convention had sort of been, well, if the Court of Appeal did not reduce the damages by more than 25%, if the Court of Appeal didn't feel they should be reduced by that amount, they shouldn't interfere with the trial judge. There's a discussion by Mr. Justice Noonan at the end. In that case, he said, no, what you do is you look at what we awarded. They awarded €200,000. You add 25% to that, that's €240,000, and that is the figure that the High Court should have given, Mr. Justice Noonan said, and on that basis it was justifiable for the Court of Appeal to interfere. A final interesting point is that there was there's a separate judgment on the 3rd of November, 4 weeks ago, the cost aspect, and I suppose from a defendant and plaintiff point of view, the defendant there prior to the High Court, prior to the appeal came on, offered $351,000. The Court of Appeal award, when special damages were taken into account, amounted to just over €383,000. So the plaintiff got more than what was colloquially called the Gagan letter, but had got less than what he'd been awarded in the High Court. The Court of Appeal there made no order as to costs on the appeal, and the factor which swayed Mr. Justice Noonan was the fact the plaintiff hadn't made a counter offer to the defendant's offer. So the plaintiff, in fact, suffered quite a sizable, or his lawyers perhaps suffered quite a sizable loss because they did not get their costs of the appeal. The next case dealing multiple injuries is the decision of Mr. Justice Coffey of July also of this year. There's a case of Lipinski and Whelan. This was an accident. The plaintiff was 15-year-old schoolgirl at the time. She was knocked down by a car on her way to school. And the incident had happened in December 2019. Now, in that case, there was post-traumatic stress disorder injuries and physical injuries, and the physical injuries amounted predominantly to a scar to the left thigh. There were a number of minor injuries to the left wrist, left ankle. And Mr. Justice Coffey went through the personal injuries guidelines because they applied, and I think it's the first time a judge had done it. And he set out a number of highlights and points which a trial judge should do. He said, at the conclusion of the evidence, the judge is required to ask both legal parties what the dominant injury is. That's the first thing. Then secondly, what damages bracket most closely matches that dominant injury and the evidence regarding that injury. Thirdly, where the injury falls on the relevant scale of damages. So once you've identified the dominant injury, where it then comes in the scale, which, as you know from the injury guidelines, there is. And then once that is done, the judge is to make a finding of fact concerning the dominant injury and how the guidelines then impact on the court's award. And then he went on, the judge must adhere to the legal principles which the guidelines mandate the award is, mandate the award is to be just and fair to both parties, not just the plaintiff, but also to defendants, and also to be proportionate to awards involving injuries of lower or greater magnitude. So again, taking the proportionality point from Meehan, the award is to be proportionate. Now, Justice Coffey went on and said, if the judge is going to depart from the guidelines, and they are entitled to depart from the guidelines, but they must give reasons for doing so, and those reasons must be cogent, rational, and justifiable in the interests of justice. And however, but if a departure does arise, if the judge is entitled to depart from the personal guidelines, Mr. Justice Coffey highlights that they must do so. It's mandatory. They don't have a discretion. And Mr. Justice Coffey did note, though, it's not something that would arise in a straightforward case. So it is open to plaintiffs, obviously a defendant lawyer isn't going to be doing it, is to say to the judge they are entitled to depart from the guidelines, and if the case warrants it, the judge is mandated to do so. Then dealing in that case, Mr. Justice Coffey, obviously he was dealt with multiple injuries. In that case, he went on to say the award for damages must be for the most significant of the injuries, and then after that there is an uplift for all of the effects of the lesser injuries, so that the plaintiff is fairly and justly compensated. And then again, Mr. Justice Coffey used the phrase proportionate and fair award. In that case, the post-traumatic stress disorder was found to be the dominant injury. In that case, the 15-year-old, by the time the case come on, admittedly less than 3 years later, she had suffered educational disadvantage. She had missed school. There was a question whether or not her leaving certificate had been impacted upon. But Mr. Justice Coffey there gave €35,000 for the post-traumatic stress disorder, in that it had impacted into this educational aspect. And Mr. Justice Coffey gave €25,000 for the other injuries, the predominant one being the left thigh scar. So what one can conclude from that is, if there was no post-traumatic stress in that case, the evidence was she had had nightmares. Not surprisingly, she'd been knocked down by a car. You might think, oh, that's €25,000 for a left thigh injury. My point would be no. If the only injury or the dominant injury there had been the left thigh injury, I would suspect it would have been a much greater award than €25,000 for a young schoolgirl. This was a 12-centimetre scar, apparently. But interestingly there, it was viewed that wasn't the dominant injury. The dominant injury was the post-traumatic stress. The second point is the guidelines do provide for post-traumatic stress disorder. The Book of Quantum did not. And as we all know, the Personal Injuries Board rejected any cases where there were psychological injuries. So post-traumatic stress disorder is now provided for in the guidelines. The phrase recognized psychiatric illness is used. So anxiety, stress from an incident would not apply. You've got to show you've suffered a recognized psychiatric injury. I'll reference against myself a case called Quinn and Topaz, where Ms. Justice Egan last year gave €100,000 for post-traumatic stress disorder, which was of 10-year duration. That was a case where the plaintiff had witnessed the gangland hit of a customer into a service station in Limerick back in 2010. And Ms. Justice Egan there said she was entitled to €100,000. There was no doubt she had suffered post-traumatic stress. There was no doubt she'd been affected by it. It was reduced because in that case, the actual negligence factor was not that she had witnessed this. There was no foreseeability. It was a question arising out of not having a panic button, and she was awarded €30,000. So that's a decision there which I think is a useful one for at the high end. Mr. Justice Coffey is given €35,000 here for a 3-year or possibly less post-traumatic injury. And then just the final point arising from that is obviously Meehan is going to arise less and less because the judicial guidelines have now overtaken the Book of Quantum. So Mr. Justice Coffey's decision is going to be more pertinent into the future. The next case just talk about is a case of Toomey and Joral. It's another decision, I think nearly all of them are Mr. Justice Noonan in the Court of Appeal of June of this year, 16th of June. This concerns Reddy and Bates. We all know Reddy and Bates, 1983. What is the deduction to be made predominantly for the loss of earnings that a plaintiff is claiming for? And in that case, the incident had been in 2015. The plaintiff, she worked, it was an injury at work, and there was no doubt about the injuries. The question was just about her loss of earnings. Ms. Toomey, in that case, she'd left school at 18. She'd been in continuous employment ever since. She'd taken 1 year off for a secretarial course. One of her managers, she was working in Boots at the time of the case. One of her managers had described her as an absolutely brilliant worker. After the incident, she left work for a period of time. Then she went back to work doing effectively a half a week, 22 hours. Then at the end of 2017, 2 years after the incident, she was back at a 37-hour week. Then I think she said in 2018, middle of 2018, 3 years after her incident, she said her phrase was she hit a wall, and she went back to doing effectively a week of 22 hours. In that case, Mr. Justice Meenan, who heard it in the High Court, he made a 40% reduction on the basis of Reddy and Bates. And what Mr. Justice Meenan took into account was the fact that the plaintiff was working in retail, which could be impacted on by online shopping, and Mr. Justice Meenan also took into account COVID restrictions, and that COVID was a vagary of life which nobody had ever foreseen. The defendants appealed the loss of earnings both past and into the future, and appealed on the basis there was no evidence for the past loss of earnings and no account for the plaintiff's ability to do sedentary work into the future. And the plaintiff cross-appealed the 40% deduction. And in that case, there was an interesting discussion on what a High Court judge set out as to what their findings of fact are, and reference to the famous Hay and O'Grady case, and also a 2021 case of the Court of Appeal of McCormick and Timlin. Now, interestingly, in that case, the defendant had failed to put in cross-examination to the plaintiff that she was able to do sedentary work. The plaintiff, as I say, she worked in retail, which obviously involves standing around, but the defendant didn't put to her, well, Ms. Toomey, you would be able to do sedentary work. And I think another factor which COVID has underlined to us and going forward is working from home. Is if a plaintiff says, well, look, I'm not able to get on a bus or a train or cycle to work, there is the factor now, well, working from home is now far more prevalent and obviously going to be accepted into the future. So the defendants, and they hadn't put it to her that, well, look, you could do sedentary work and therefore there shouldn't be any aspect of the differential between a 22-hour and a 37-hour week. And in the Court of Appeal, Mr. Justice Noonan looked back at Reddy, and he looked back at the fact, and Reddy and Bates, and we all look at Reddy and Bates deals with the economic situation at the time. And as Mr. Justice Noonan said, look, there's economic booms, there's economic recessions. The labour market as it is waxes and wanes. So it doesn't matter what nature of employment you are in, there is always going to be that factor. Now, Mr. Justice Noonan said, however, you've got to look at the other exigencies of life, like life expectancy. That's got to be taken into account. You've got to also take into account whether the plaintiff has suffered another injury. The plaintiff may have suffered another injury since the incident, the subject of the claim. And the fact, and you've also got to look at the nature of the plaintiff's employment and whether it's a precarious nature of employment. Are you working for a cryptocurrency firm? Or are you working in the civil service, for example? I mean, to give two extreme examples. So in that case, Mr. Justice Noonan acknowledged, as he said, it's impossible to list these exhaustively, being the factors to take into account. But factors such as the plaintiff's employment track record, this plaintiff had a very good track record, and the relative security of employment. And Mr. Justice Noonan acknowledged it was probably difficult to envisage a case where there would be no deduction. He also highlighted the spectrum for Radian Bates really has always been 15 to 25%. That's sort of the accepted band. And Mr. Justice Noonan said, and again this would be more relevant to the defendant's side, if you're going to go outside that band, i.e. probably argue for less than 15%, you need to put evidence to justify a judge's departure from that. So again, in that case, Mr. Justice Meenan, he had reduced it on the basis of which there was no evidence, i.e. that online shopping and COVID, this wasn't any evidence that anybody had led, and on that basis Mr. Justice Noonan made a 15% reduction from the future loss of earnings claim in that case. So it's just a useful review of Radian Bates. Everybody just talks about Radian Bates, and I think a lot of people just don't really know what it's talking about, not surprisingly, because it's at this stage going on 40 years old. The next case I just want to talk about is Keating and Mulligan, which visits, and if anybody is interested, I will bore you for 45 minutes with a talk I gave to the Dublin Solicitors Bar Association on Section 26. I hope all of you know what Section 26 is. This is where you want to make a case that the plaintiff has exaggerated their claim to such an extent that it should be dismissed. This is again a decision of Mr. Justice Noonan of November of this year, 9th of November. In this case, the plaintiff was involved in an accident on the Lewis in 2016 June. She suffered an injury to her shoulder. It appears from the High Court, Mr. Justice Cross heard it, it would appear the plaintiff gave her evidence and was cross-examined, and after her cross-examination, a general practitioner's report was obtained by the plaintiff's solicitor and given to the defendants within 2 days of being obtained. And what this general practitioner report divulged was that the plaintiff had had a second incident on the Lewis a number of months afterwards, I think 18 months later. And interestingly, what then occurred was that the case adjourned to allow the defendants get the plaintiff's post-accident medical records, including the second incident. In that case, the plaintiff had been asked in her notice for particulars, the standard question, have you been involved in any further incidents? And the answer had been given no. When the matter came back to Mr. Justice Cross a number of months later, and after discovery had been made, the plaintiff was put back into cross-examination. And it was put to her that she hadn't divulged the second incident. The plaintiff actually said, well, it wasn't put to me. You only asked me about my incidents pre this one, which was in fact the case. But the evidence sort of got derailed and went off on a complete cul-de-sac. And it was never actually put to the plaintiff, well, why didn't you tell us about the second accident? The position was then maintained in a Section 26 because it was asserted the second general practitioner's report had been deliberately withheld until the plaintiff finished her cross-examination. Mr. Justice Cross found that there had been no intention to mislead, and he awarded €10,000 aggravated damages. And just in the talk I gave back in April, I made the point that Section 26, it's now 21 years old. When it started, it was the defendant's new toy, and it was probably overused and had started off very successfully. And there's the famous case of a Mr. Platt who fell out of the window in Kinsale. But in more recent times, the judges had been becoming a bit wary of this application because it was probably being used a little too often. And in this case, I say Mr. Justice Cross awarded €70,000 general damages and 10,000 aggravated damages. The defendant appealed, and in the course of that appeal, which was heard by Mr. Justice Noonan and Mr. Justice Collins, they referred to another case, which is a decision of Mr. Justice Collins, those of Sullivan and Brosda. Mr. Justice Collins and Mr. Justice Faherty gave the judgments there. That was another Section 26 case. I won't go into that one. That was one where the plaintiffs came with her actuary report maintaining loss of earnings of over €1 million. We're all aware that the actuaries work on the basis of what the full amount may be, life expectancy, work expectancy, etc. In the Brosda case, The plaintiff pretty much early on in her cross-examination had conceded that her loss of earnings couldn't be over £1 million because she was able to do certain work, and a Section 26 was unsuccessfully made before Mr. Justice Barr. I just think I'll just quote, sorry if you just bear with me, because I think it is worth quoting what Mr. Justice Collins had said in that case, which is recited in Mr. Justice Noonan's case of Keating, as to where and where you probably should not bring a Section 26. Mr. Justice Collins in Brosda said, "It is important that courts should have the power to dismiss fraudulent personal injuries actions. Such actions amount to an abuse of the court process and also impose significant societal cost. But it is equally important that there should be a high threshold for exercising that power. The proofs required are identified in Section 26 and have been explained in the authorities. The authorities emphasise that a court should be careful and cautious about making an order under that section. The authorities also counsel caution on the part of defendants in invoking it." And he went on in paragraph 74, "No issue of aggravated damages arises on this appeal, but defendants should be mindful that where an application for a Section 26 order is made without any proper basis, the court may consider it appropriate to mark its disapproval by an award of aggravated damages if the risk of such an award being made serves to deter the making of marginal applications. That is no bad thing." And after that quote, Mr. Justice Noonan, reverting back to Keating, highlighted Mr. Justice Collins had recognised it was a fundamental requirement that a Section 26 application that the defendant must establish that the plaintiff has been guilty of dishonesty. And just further on in that, at paragraph 35, Mr. Justice Noonan, a useful quote there. The defendant was relying on the plaintiff's evidence, and Mr. Justice Noonan paraphrased that. "In support of this contention," this is the defendant's contention, "one of the grounds relied upon by the defendant is that the plaintiff's evidence conflicted with her pleaded case. That really is a fairly commonplace occurrence in any personal injuries action, and while sometimes providing fertile ground for cross-examination in the hope of undermining the credibility of a plaintiff, is hardly of itself grounds for invoking Section 26. So Mr. Justice Noonan there sets out, yes, certainly you can cross-examine, i.e. in that case the plaintiff hadn't divulged the fact of the second incident. It can be cross-examination. And Mr. Justice Noonan, as I say there, yes, it's not unreasonable to maybe make a Section 26 application in such circumstances. But, you know, and also in that circumstance, that mightn't lead to an award of aggravated damages. But in this case, the plaintiff was, and her lawyers in essence, were also accused effectively of perjury and litigation misconduct by not disclosing this report. And Mr. Justice Noonan, in paragraph 63 of that judgment, makes and reverting back to Mr. Justice Collins, that the decision really should be noted to deter marginal applications, i.e. if it's a marginal case, it's probably better just to sit on it, as opposed to, because you may not find favour with the judge who will give an award of aggravated damages. I think there is a previous decision where €10,000 had also been given by Mr. Justice Cross for a wrongfully invoked Section 26 case. So it seems to be sort of, and that case of Mulligan, it strikes me as being a very extreme case. So it would appear €10,000 damages is possibly the penalty you'll pay, and it's a matter for defence lawyers if they want to go there. Just two very brief cases. There's a case of Cusack, or Kuczak. This is a decision again of this month, 9th of November, by Mr. Justice Toomey. Its full title is Daniel Cusack and Tracy Towers number 2. There is a number 1. This is where Mr. Justice Toomey has revisited the area of recoverable benefits, which, as you are aware, is an area that exercises him greatly. The facts of this case, as I understand it, is, first of all, I mean, a recoverable benefits, as you may or may not be aware, is where both parties agree the plaintiff has recoverable benefits of, in this case, it was €90,000 for illness and invalidity benefit. There was an agreement that the case would settle. It was a Galway High Court case. There was an agreement the case would settle. there was an agreement the plaintiff wasn't going to incur loss of earnings or that the case was being succeeded on 100%. So the case was never heard by Mr. Justice Toomey. That's the first thing. If the case is heard, there is no difficulty with the recoverable benefits because the judge will then have heard the evidence. The difficulty only arises where, as we all know, on innumerable occasions, parties are going in and saying, would the court note a determination of 50-50 liability, 75% against the plaintiff? Would the court note the plaintiff maintain no claim for loss of earnings, leading to a situation where the insurance company doesn't have to pay out to the Department of Social Welfare? In that case, it would appear from my source, they went in on the second day and they said to Mr. Justice Toomey, could you make a ruling? Could you make a consent order? And he refused. And he said, I haven't heard the evidence, how can I make a consent order? And what then appears is that the defendant suggested, well, maybe put a stay on any order, and we'll hear from the minister. So rather surprisingly, the counsel was engaged by the Minister for Social Protection, who came in and made submissions to Mr. Justice Toomey. This was heard back in July. And interestingly, Mr. Justice Toomey, in his judgment, takes on board the minister's interpretation of Section 343, which is the appropriate and apposite section. Now, I'm not quite sure if a minister can give their interpretation of legislation. I don't think it should be done at all. He took it on board, and he also felt, and he had made this finding in a previous case, that a consent order of the court was not an order of the court. Again, it seems a somewhat surprising finding where consent orders are made often. And Mr. Justice Toomey, though, did concede at the end of that judgment, this was an area, it hasn't been looked at by an appellate court in this jurisdiction. And in that judgment, he sort of implores, I think, the defendant there to appeal it so that we'll have a decision from an appellate court. But the difficulty is the appellate court is dealing with this in a vacuum. I mean, it doesn't have the facts, it doesn't have the plaintiff, it doesn't know, well, is it a 50%? What's the case? I mean, this is simply now a statutory interpretation question. And as Mr. Justice Toomey has highlighted, the problem with these orders is that plaintiffs and defendants, and yes, it suits the defendant side, the insurance companies, because they don't have to pay to the taxpayers, Mr. Justice Toomey repeatedly says, €45,000 in this case, for example, and that the taxpayer is losing out upwards of 20 million since this came in 2013. This is unfair on the minister because the minister is unaware of this. Just thinking about it, one thought I've always had is it not unfair on insurance companies that the Department of Social Welfare are paying out for illness and invalidity pension in circumstances where insurance companies can't question that at all? I mean, this is simply being paid out, and an insurance company every few months gets an up-to-date recoverable benefit certificate, and they've no input in that. So that just seems to me there is a slight inequality of arms there. Interestingly, in that case, the Chief State Solicitor Office wrote a letter before this came on saying that their interpretation of the section was that it didn't apply to consent orders. It only really had applicability where a judge had heard all the evidence and made a 50-50 finding or dismissed a case or found there was no loss of earnings. So despite all of that, we have a situation now where Mr. Justice Toomey has said, I'm not going to make a consent order if you come in with them. What is now happening since this judgment is that, and I saw a few of them today, is that you go in and the normal order, if I could put it that way, is made with the the defendant to give an indication that the minister will be notified of the order, and there's a 28-day period for the minister to come in to review, set aside whatever the order. Again, I've asked around colloquially, and I think the amount of times an insurance company has been asked by the minister to repay these, I think, are like hen's teeth from what I gather. I mean, single figures, it would appear. But so what's the outcome of all of this? What's the situation? I think it's a mess, to be frank, and I think something has to be done about it because the problem from defendant's point of view is you have a 90,000 RBA, you don't want a case to run for 6 days, you accept because you have a plaintiff who's saying, I'll take 50-50, I'll take 25% liability. Economically, from a defendant's point of view, you're not going to run the case. You want to settle the case. But how else are you going to avoid your 90,000 recoverable benefit liability? So you have this remarkable situation. You're going to be forced to run cases simply to get a determination. You and the plaintiff may have agreed it's a 50-50 case, and the judge hears the case and throws it out or finds 100% against the insurance company. So from that point of view, it is a situation that has to be absolutely clarified. And the mechanism of it, I'm not quite sure what it is, because it is really a statutory interpretation question, or it's a statutory instrument to amend, or simply a legislation amendment, because it doesn't suit either party. I mean, in a way, the plaintiffs are agnostic on this, because they don't mind. It's deducted from their loss of earnings, their past loss of earnings. As you know, it only arises for 5 years maximum. They don't mind. They've got their loss of earnings to date or whatever. It's the insurance company are left footing the bill, as it were. So it is, as it said to me, it is, and everybody seems to agree, it's a mess. The very final case, I'm not going to go into it in any depth, a case called Duffy and McGee, another decision of Mr. Justice Noonan and Mr. Justice Collins. I think, as you're all aware, Mr. Justice Noonan seems to get the personal injuries appeals. Again, a decision literally of the 7th of this month, and this deals with expert witnesses. An interesting enough case where the plaintiffs had suffered, would appear they got over 2 million in damages. There was 2 separate cases taken by a husband and wife. There was exposure to a chemical substance while their house was being insulated. And the expert witness in this case, A, was called a bit late to the day and disclosed by the defendant, and was a Dr. Thompson who flew in from America. And Dr. Thompson went on any level outside his ambit as an expert witness. And there's 2 lengthy judgments from Mr. Justice Collins and Mr. Justice Noonan. And Mr. Justice Noonan highlights that the expert witness, he called the plaintiffs liars, accused them of trying to deceive the court in circumstances where they didn't tell the court or their expert about the fact the house was also getting other renovations. That was pointed out, well, that was just simply incorrect. Dr. Thompson also decided to give a lecture on res ipsa loquitur and Irish law. Dr. Thompson also decided to give a bit of medical evidence, which was outside his ambit. So what Mr. Justice Cross, who heard the case in the High Court, he had ruled out this expert witness evidence in his totality. He just said, look, this is not an expert, and he's gone completely, using my words, off the reservation. And the Court of Appeal upheld that. There are 2 long judgments, but they really just recite Irish cases, English cases, and don't really recalibrate what the duties of an expert are. You know, what an expert should be told, what information they should be given. And, you know, the fundamental point is they are independent of their client, whether it be plaintiff or defendant. Their obligation is to assist the court. So it's just a very recent reminder of all of that. As I say, if you want to read it, it is quite amusing how far off the spectrum Dr. Thompson went. I suspect the expert witness pool we have in Ireland is obviously very small in any area. We do, I mean, that was Dr. Thompson was a toxicologist, and it's not an area we have many of in Ireland. I think nearly all the expert witnesses we know, whether we be plaintiffs or defendants at this stage, are aware of their obligations. But I think the lesson is, and there are other more recent cases dealing with expert witnesses, is just that they should be properly briefed, as it were. They should be shown the bad things from a plaintiff or defendant's point of view, as it were, and deal with those. And you shouldn't necessarily just give them a uncontextualized history of an incident. So there are my brief resume. I hope I've stuck to my half an hour, as Anne insisted I would. Thank you.
And a happy Christmas. Thanks very much to our speakers for their enlightening talks. I just wanted to just detain you just for a few more minutes. I promise it won't be very long. But as Michael was saying, he's stepping down now, today officially, and the baton passes to Noel. But I just wanted to recap a little bit on what Michael was saying. It is 3.5 years, I think, since Foyle Island was first officially launched in the more expensive suite down the road. It's been an extraordinary journey. Nobody could have seen the pandemic coming along, and that probably did change the plans that we might have had. But I think that sort of take on history slightly overlooks the fact that in the meantime, we've been able to deliver nearly 30 online learning events. That cumulatively, given the number of people that dialed into those, produced in excess of 2,000 hours of CPD for lawyers. So I think that's a great achievement in anybody's book, particularly in extraordinary circumstances. So Noel and I will have a chat with the rest of the committee as to where Foyle Island goes from here. One of the things I would really love to see is a little bit more of a two-way street between the other jurisdictions that are in Foyle, England and Wales, Scotland, Northern Ireland. A couple of things that came up in the talks. I mean, you were talking about Section 26. I'm not quite sure what our equivalent is in England and Wales, but it's about fundamental dishonesty, which is a strange sort of phrase, really. It's a bit like being sort of partially pregnant. You're either dishonest or you're not. So fundamental dishonesty is an issue, and it's you hinted it's an opportunity that's perhaps been well used by insurers. But there's a challenge coming up that says that under England and Wales law, a finding of fundamental dishonesty should not completely wipe out the entire claim. It should only wipe out the bit that's related to the dishonesty. So I think there's a lot of things that we can learn from the various jurisdictions that Foyle talks about. Credit hire. We've had 30 years of getting that wrong and doing it the wrong way. So we'd be delighted to sort of share experiences on this. The discount rate is coming up for re-examination in England and Wales this next year. We'll be doing a lot of talking about it, and 2024 is the final date by which we have to settle on a new discount rate. But I understand that you have discount rates that apply to different heads of claim. Now that is not the situation in England and Wales, so we'd love to know. So all I'm getting at is I think there's a great opportunity for swapping of experiences, and indeed that really is the basis of Foyle and bringing firms together, whichever jurisdiction you're in, to swap those experiences and learn together. But enough about Foyle. Just going back to Michael, I honestly would say that Foyle Island wouldn't have got off the ground at all if it wasn't for Michael's sort of vision and energy and grabbing the opportunity as he saw it. And I'm really going to be, I think, eternally grateful to him for doing that. It's been an absolute pleasure to work with him. He's very, very sharp and very switched on a great deal of things. So I wanted to buy him something to mark the occasion, but he said he didn't want anything, so I haven't got him anything. So, but I think a warm and generous and long-lasting round of applause is the best we can. Thank you. Right, so I'm now going to officially pass the baton over to Noel.
Bit hot up here. Thanks very much, Lawrence, for stealing pretty much everything I was going to say. My name is Noel Devons, and for anybody who doesn't know me, and that's probably most of the people in the room, I'm a professional negligence defence lawyer with Kennedy's. So pretty much everything I heard from the two gentlemen today is news to me. I haven't dealt with it at all. So I'd like to say thanks to both Andrew and Dean for giving us the benefit of their insights today, and just while we have this expertise and experience in the room, I just ask if anybody has any questions for the two gentlemen. You might put them to them now. Put you on the spot.
Can I ask, just as Lawrence mentioned earlier, the discount rate is very prevalent discussion in London at the minute, because obviously we're at the 1% here, we're minus 1.75 in the north, minus 0.75 in England. We're having a few discussions on large cases where opposition are saying they won't deal it 1 or 1.5 for specials. Where do you get the feel it's going? Or is there going to be a case that's going to review Russell?
There's one started today, I hear, on the rate of return. The short answer is I don't know. To be frank, I won't pretend I know. So, but there is one still. Declan Buckley, as you probably all know, is involved in it.
So is it's already run, or we're going to
It started today, I hear.
start?
So,
No more questions.
Sorry, excuse me, can I just ask Dean about serving district court proceedings by registered post? How should one serve district court proceedings if you don't encounter that problem?
Well, you can serve them your ordinary service just by personal service. If you choose registered post, you'll fall into this
Ironically,
section.
but can you serve, you mean by summons server or
Yes.
ordinary
By summons serve, by personal service.
personal service? And
Or if it's a
then-
company, you don't need registered post, it could be ordinary post.
So to avoid that problem, just serve by summons server?
Yep, or be careful if you're going up to the time to serve by registered post on the day you issue them.
Okay. Okay,
So
thank you.
in the case, they had held off for a couple of months, or the summons was
Yes,
sitting in the file for a
yes.
week or two.
Don't delay.
Don't delay.
Okay, that's the end of the questions. As Michael has mentioned earlier, I'm taking on the baton, and to be honest, it's a slightly dubious honour. I feel like I'm somebody, this is the Lister equivalent of following Alex Ferguson, and we all know how that worked out for those individuals. Honestly though, I think Michael has done himself a grave disservice in terms of downplaying everything he's done for Foyle and with Foyle. We got up and running, as Lawrence said, in 2019, and we kicked off with some extremely interesting in-person webinars. Then all of a sudden COVID came along and kicked all that to touch, but nonetheless, under Michael's stewardship, we went virtual and started dealing with a multitude of webinars which were very well attended. We did that for effectively a year and a half, and then we had our first hybrid in-person webinar last July, I think it was, mid-July, and this is our second hybrid in-person event. So we're very happy to be back in a situation where we're a kind of relative normality, and we're very much looking as a committee to drive on from the foundations that has been built under Michael's stewardship. So that's what we continue to do and will be doing over the next number of months. We have several ideas in terms of what we do next in terms of CBDs and webinars, and we'll be letting you know about all those in due course. And that's pretty much it from me now, and all I'd like to do is just wish everybody a happy and peaceful Christmas, and we'll see you all in the new year.